Ready, start. Learned counsel for the appellants submit that the present case is not of a premeditated murder but a result of a free fight that ensued between the two groups. As the injuries were sustained on both sides, the possibility of the appellants exercising their self defense cannot be ruled out. Also, the fact that none of the witnesses could attribute a specific role to any particular accused, thus, it indicates that it was a case of free fight. Additionally, it was the side of the appellants that lodged the first FIR. It was also argued that the cross FIR from the side of the complainant was in fact lodged after 3 days of the incident by the son of the deceased Dileram and not by the injured eyewitness. Learned counsel for the appellants have also questioned the testimonies of the eyewitnesses. In a nutshell, it was argued that the conviction of the appellants under Section 302/149 of the IPC is totally misconceived, and if at all they are liable, they can be liable only under Section 304 Part 2nd of the IPC, as their case falls under 4th exception to Section 300 IPC. Per contra, the respondent state has argued that the appellants had the motive for killing Dileram since the consolidation proceedings were pending between the parties. But in the consolidation proceedings, the field was given to Dileram, which enraged the appellants. It was also argued that it was the appellants who were the aggressors. They are the ones who attacked on the complainant side. PW2 within bracket Bengal Singh bracket close within bracket injured eyewitness bracket close in his testimony had stated that the appellant's lathi contained an arc-shaped iron blade. Hence, it cannot be stated that the injuries on the person of accused are not explained. State has argued that the fourth exception to Section 300 of the IPC is not attracted in the present case, considering that it was a shared motive on the part of the appellants to cause death on the complainant side. Additionally, on the issue of delay in lodging the FIR by the complainant, the state argues that the trial court has rejected this contention as the delay was well explained by the complainant side. Thus, the present appeals need no interference and the conviction against the appellants be upheld in toto. The rival submissions now fall for our analysis. It is well settled by judicial pronouncement that Article 136 is worded in wide terms and powers conferred under the said article are not hedged by any technical hurdles. Thus, when the judgment under appeal has resulted in grave miscarriage of justice by some misapprehension or misreading of evidence or by ignoring material evidence, then this court is not only empowered but is well expected to interfere to promote the cause of justice. It is not the practice of this court to reappreciate the evidence for the purpose of examining whether the findings of fact concurrently arrived at by the trial court and the high court are correct or not.